Pursuant to an agreement negotiations held at that time, on July 30th, 2025, Mr. Carpenter pled guilty to predatory sexual assault against a child. The agreed upon sentence is an indeterminate sentence of 17 years to life. Also, an order of protection was requested as part of the disposition. Also, given the nature of the offense, it requires registration pursuant to the sex offender registry. Also, the defendant entered a waiver of appeal with certain exceptions that I'm sure we'll address today. Further, I did receive the various filings from the defense and the people. But let me first ask, Ms. Schwartz, are you aware of any legal reason we cannot go forward with sentencing today?
I'm not, Your Honor.
Okay, thank you. Mr. Woodfork or Ms. Martin-Tom, the people move sentence. I did receive notice from the people. Would you like to be heard further, Mr. Woodfork?
I apologize, Your Honor.
I did receive notice from the people regarding, you filed a notice that the victim's mother would like to be heard in sentencing.
Your Honor, we have an impact statement that we just read on behalf of.
So you're going to read it on her behalf?
Yes.
Okay.
And for the record, Your Honor, we are going to substitute the child's name is listed in the impact statement, so I will say John instead of the child's actual name, just to maintain the anonymity of that child.
Okay, thank you.
Your Honor.
Go ahead, Mr. Woodfork.
Thank you, Your Honor. My son John is delayed with autism, which means he cannot always tell me what he feels, why he is afraid. I have to piece it together through his tears, his silence, and his behaviors. For nearly a year, he could not even bring himself to take a bath. Something so ordinary, something every child should feel safe doing, became a reminder of terror for him. Swimming, something that once made him smile and laugh, was gone from his life. Only recently has he tried again, but even that fragile progress comes with fear. John clings to me when I leave for work, terrified I won't come back. He cannot fall asleep alone in his room. He struggles with brushing his teeth, with potty training, things that should be simple, yet for him are filled with fear. Even a visit to the dentist ends in tears for him and for me. Every day, I am haunted by the same question. Will my son ever be okay? He cannot speak the weight of his trauma, but he lives inside his body. It shows in his fears, his triggers, his struggles. For him, healing is not temporary. It is a lifelong journey. The defendant did not just take away safety. He stole John's innocence. He shattered my son's trust in the world. He stole my peace as his mother. I tried to comfort John, to speak the words he cannot, but no amount of love can erase what was taken. So while the defendant may face 17 years behind bars, my son and I face a lifetime of therapy, a lifetime of questions, a lifetime of walking carefully through the world, not knowing when the next reminder of his trauma will appear. A lifetime of fears my child should never have had to carry. This crime follows us every single day. It sits at our dinner table. It lingers in the silence of our home. It shows up in the smallest daily routines. Time will not make it disappear. Your Honor, I ask you to understand that the weight of this pain will never leave us. My son deserves safety and healing. And I, as his mother, will carry this pain and fight beside him for the rest of our lives. Your Honor, there's not much more I could say to truly depict the horrors and heinous nature of this crime and the effects that this abuse will have surrounding this case and this abuse are horrific, are heinous. And there are many levels and layers that explain truly how upsetting, unnerving, and tragic this is. One of the main elements, factors in this case that make it unconscionable is that Mr. Carpenter is this child's father. Mr. Carpenter was supposed to protect him. The nightmares, the horrors, the struggles, the fears that his son will have potentially for the rest of his life are due to the actions of his father. And I think we are all lucky and grateful that the circumstances in this case allowed us to see what happened. Because as the child's mother stated in her impact statement, this child suffers from autism. Yeah.
Hold on for a second, there's some noise coming from the back. Sorry about that, go ahead, Mr. McFarland.
This child suffers from autism. This child has trouble relaying his feelings, emotions, and communicating those things verbally. The truth of the matter, Your Honor, is but for these actions being caught on video, we may never have been here. This abuse may have continued on and on and on. If you look at Mr. Carpenter's pre-sentence report, he notes that he's had an alcohol abuse problem, that he started drinking since he was 15 years old, that he would drink daily vodka, handles of vodka, and that he would be drunk and intoxicated, and it is that alcohol abuse that caused us to be here today. Judge, I would say that having an alcohol abuse problem does not in and of itself make you a sexual abuser of a child. Being drunk does not cause you to sexually abuse your 3-year-old child. But if that is the case, if that is the impetus for why we are here, then my God, this child may have suffered more than we know, because he himself said he drank all the time. But again, luckily in this circumstances, we had the video, we saw what happened. We had Mr. Carpenter's fiance come forward and speak exactly about what she saw and got that child out of that house. She has made a decision to marry Mr. Carpenter and go forward with that engagement. I can't speak any more about that versus her taking his side versus the child's and who she is actually trying to protect. But we know that in that house, he had no protection. In that house, he was succumbed to a victimhood. And Your Honor, in this investigation, we had the honor of working with a great detective from the Sheriff's Police Department. Detective Blackford and I worked this investigation from the beginning. And we made a concerted effort to limit the exposure of this video to anyone outside of our specific circle and in this investigation because of those horrors. And the horrors continued for us and others when you heard the sounds that echo, the cries that echo, the screams that echo. Not only what you see, it's what you hear. And you hear the terror and the pain of that child. Your Honor, Mr. Carpenter accepts responsibility. He has pled guilty. He is accepting his sentence, but not for a few minor statements as to why he thinks it's unreasonable. When asked about the proposed sentence, he states it's absurd, given his lack of criminal history and circumstances leading up to the offense. I would say that the only absurdity here is that he thinks that this sentence is too much. That 17 years to life for what he did to his son is too much. And that because it only happened one time, that he should be granted more leniency than what he was given. And Your Honor, for the record, the maximum sentence is 25 to life. Again, it is absurd to think that leniency should be granted because you only did it once. And as you heard in the victim impact statement, that one time is going to stick with his son for life. It has impacted his life now and forever. Your Honor, this sentence is appropriate, more than appropriate. And lastly, Ms. Schwartz has provided the people in the court memos, reference letters, and pleas to take emotion out of this. And Judge, I would argue that emotion is one of the things that shouldn't be taken out of this. That you can feel and understand what we are dealing with when we're looking in the eyes of individuals that can do these horrible, heinous things. If you can turn off your emotions in the eyes of this, that says more about you than anything else. So again, Your Honor, I would just ask that you go forward with the agreed upon disposition that the court has already laid out. Thank you.
Thank you, Mr. Woodford. Do you have any proposed orders of protection, by the way?
Your Honor, we have a proposed order of protection based on the fact that he is going to be getting 17 years to life. We have left that blank, but we are requesting a lifetime order of protection, so we would ask that that order of protection expire in 99 years.
Yeah, can I see that, please? Yes, sir. Anything further from the people, Mr. Woodford?
No, Your Honor.
Ms. Schwartz, is there anything you'd like to say before the court imposes sentence? I will note that I received the sentencing memorandum, the attached materials that you've submitted, and those you requested those be attached to the commitment as part of this process.
I thank you, Your Honor, and ask to be made part of the record. At this time, unexpectedly, I'm also asking for my omnibus motion to also be sent to the Department of Corrections because it outlines the facts based on the video. So I ask that that also be done. If the court needs me to provide a duplicate copy, I'm happy to do so. I get it, right? We have cameras here. We've got some theatrics. This is an agreed upon disposition. And it was agreed upon not because Mr. Carpenter was failing to accept responsibility for this case whatsoever. It was agreed upon because he had no other choice, and I did not believe it was a just sentence. So if they're taking position with the fact that we're disputing the 17 to life as being just under these circumstances, that's on me. That's not on Mr. Carpenter whatsoever. I'm not going to allow to sit here and allow him to take responsibility and then also have them say he's not taking responsibility. I don't think it's fair. And if emotion is what's driving this case, then that's not the people's job. The people's job is not to have emotion drive their decision making, and that's been my issue with this case from the beginning, is that my conversations with the district attorney's office have been based on emotion as opposed to the collective facts. There is no dispute that Mr. Carpenter was absolutely not drunk, out of his mind intoxicated. That very respected Detective Blackford, he even noted it at grand jury. He noted it before he spoke to Mr. Carpenter that night. The videos that I provided to the court also show it. And but for the fact that this is an age-based offense, this is the only case I've ever been involved in that I absolutely believe I would have been able to prove intoxication, which is a nearly impossible defense based on everything we have. We have a liter of alcohol on the front porch, which has this much left. I'm going to say it has less than a quarter left in the bottle of vodka, which was a liter. When Mr. Carpenter goes upstairs, he leaves his front door wide open. He goes up to a room, to a camera that he installed. And after the crime, when he's being questioned, we waived the hearing, but I would say still under the influence, he tells them, hey, there's cameras. I can't believe I'm sitting here. I could defend as a prosecutor 25 to life on every single predatory sexual assault case. Of course you can, right? It's the sexual abuse of a child under a certain age or for an extended period of time that usually involves sexual intercourse. But that's why this statute was created. Predatory sexual assault was created to penalize the conduct. That's why it has 25 to life, the same as a murder second. So you need to look beyond the conduct itself and look at all of the circumstances. And I don't believe they've been fairly looked at in this case. That's why I fought for the exception in the waiver of appeal. But to sit here and say that there's something wrong with me because I'm devoid of emotion, or that Mr. Carpenter can't say that this is an unfair sentence because I told him it is, that's completely unfair. It's agreed upon. This court knows all the facts. Everything's part of their record. The appellate division will know the facts. And unfortunately, at this point, I'm going to ask that the videos that have the incident also be made part of the record. It can't be provided to the appellate division at this time, but if the appellate division wants to make their own factual assessments, they have to review them. So I'm going to ask that those also be made part of the record. With that said, we'd like to go forward with the 17 ruling.
Normally, when there's an agreed upon disposition, my practice is not particularly comment on sentencing. I will give Mr. Carpenter the opportunity to address the court if he chooses in just a moment. But I think it's incumbent for me to at least make an inquiry, Ms. Schwartz. And I certainly, there is a lot of emotion here, and certainly don't fault you for your zealous advocacy on behalf of your client, but you've just indicated that you believe that you could have succeeded on a defense of intoxication, and that the sentence, in your view, is harsh and excessive, for lack of a better term, that it's too severe a sentence. So, I mean, I have to ask, do you see a basis for the defendant to withdraw his plea here?
Absolutely not. Intoxication is not a defense to an age-based crime. Predatory sexual assault is an age-based crime. He has no defense. He has no legal defense for the crime. That's why he had to accept the offer. It's on video. We're not disputing his guilt, right? We're disputing the propriety of the actual sentence in this case. So, no, he's not looking to, I mean, you can ask Mr. Carpenter himself, but we've thoroughly discussed this. We're not looking to vacate his guilty plea. And I have to note the sentence is unduly harsh and severe because I want to give him a chance to have 5 appellate division justices tell him that it's not.
And I certainly respect that, and I understand it. But it's a little bit of a complex situation. When you just said that you believe that he had no choice but to plead guilty. Everyone has a choice to plead guilty or to plead not guilty. We discussed that extensively at the time of the plea, and I just want to ensure that everyone still wants to go forward with the sentencing on this matter today.
He had no choice but to accept the sentence that was associated with the issue. Because he had to plead to the indictment. This court was unwilling to offer him something less than what the people were willing to offer. So yes, it's a no-win situation because he doesn't have a defense. He has to plead guilty because he doesn't have a defense. Mr. Carpenter did not wish to proceed to trial. We discussed that thoroughly. So he had to accept the offer that was given to him. That's why we asked this court to give him something less, and the court declined. And I respect that court. I respect the court's decision. But in no way are we saying, hey, he doesn't want to plead guilty. His guilty plea wasn't knowing, intelligent, and voluntary. These are conversations he and I had extensively before he entered that guilty plea. But he is left into a decision where, okay, went to trial, and you're absolutely going to be convicted, right? This is on video, so I don't really know what defense I would have lodged. There is no defense to the crime. So he's stuck because all he can do is plead to the indictment. He's stuck with what the people were willing to offer unless this court went below. So he accepted the 17 to life. It can be both ways, where he had to plead guilty to get some consideration and still maintain that his guilt and still maintain that he didn't believe he was given enough consideration. If the court's looking to concede that, to say, oh, he pled, so of course he accepted this. He accepted the only deal that was offered to him because he was left into a situation where he had to accept that offer because trial was not a viable possibility for him.
I'm not asking you to concede anything, but I do appreciate your clarification. Anything further, Ms. Schwartz?
No, Your Honor.
And Mr. Carpenter, first, before we go forward, take a moment to speak with your attorney, but I'm going to ask whether or not you wish to make a motion to withdraw your plea in this matter.
No, Your Honor.
Right, understood, sir. Is there anything further you'd like to say before the court proposes the agreed upon sentence?
I just want to say that I am horrified and disgusted by my actions that night, and my only thoughts are about my son growing up happy and healthy.
Okay, thank you, Mr. Carpenter. First of all, the court is imposing an order of protection. The sentence is an indeterminate sentence that includes up to a life sentence. So the court is making the maximum date December 8th, 2021-24. Do you want to be heard on that, Ms. Schwartz?
No, Your Honor, no objection.
I am completing the order of protection. And I'll ask that you serve and please review with your client and sign it. Carpenter, this order of protection is a court order. It orders you to not communicate with the people named and to stay away from their home, school, and place of employment, not to engage in any criminal conduct towards the people named in the order of protection. If you violate this, you could be subject to additional criminal charges. I can see you went over it with your attorney and signed it. Do you have any questions about the order of protection? Right, this has been a, is there anything further you'd like to say, Mr. Carpenter? This has been a very difficult case for a number of reasons, primarily because of the, I don't think the word horrific does it justice, nature of the conduct here. Yes, it is true there were extensive negotiations, and yes, it is true that the people offered a disposition of 17 years to life, and this court refused to issue any lesser sentence. The sentencing range on one count, predatory sexual assault against a child, carries a potential maximum up to 25 years to life. 17 years to life is substantially less than that. So the court is recognizing that Mr. Carpenter does deserve some benefit for taking responsibility and entering a guilty plea, and I think that that is appropriately taken into account by the sentence of 17 years to life. First of all, based upon our discussions today, I just want to reiterate that it's very clear that Mr. Carpenter is not seeking to withdraw his guilty plea, and this court again finds that the plea was knowingly, intelligently, and voluntarily entered into. There's been a lot of discussion about the voluntary and voluntary intoxication is not a defense to these charges. I've reviewed the pre-sentence report. I'm incorporating that into the comments. I've reviewed the submissions from defense counsel in terms of the sentencing memorandum. And during the pendency of this case, as part of the motion practice, the court reviewed the grand jury exhibits, including the video that was submitted to the court for the court to review. And it was necessary to review that in the context of the litigation that was going on at that time in terms of the legal sufficiency of the indictment and with respect to some of the specific counts. And given the nature of the video, I reviewed it in chambers with the people's, with the assistant DAs present, Mr. Woodford from Spartan Town, and with Ms. Ford present. And to repeat what I said earlier, to call it horrific is simply inadequate to describe the horror of what that video depicted and the horror of what this child suffered in his own bedroom, a place where a child should feel the most safe. And at the hands of his father, one of the people with whom a child should feel most safe. The impact statement that was read today, the child's mother, simply echoes and documents very clearly and illustrates what she and this child will undoubtedly suffer for the rest of their lives. And I think that's important to remember as part of this equation as well. In light of that, I do believe that the agreed upon sentence was appropriate. The court, I am not agreeing to any lesser sentence. I understand that Mr. Carpenter has no prior criminal convictions. However, given these offenses and what was done to this child in these circumstances, the court believes that this is an appropriate sentence. Based upon the conviction for predatory sexual assault against a child, the sentence and judgment of the court, Mr. Carpenter be sentenced to an indeterminate sentence of 17 years to life to be served in an appropriate New York State correctional facility. Prior to release, a hearing will have to be conducted pursuant to the Sex Offender Registration Act. The court is incorporating the order of protection. The court has to impose a mandatory fee and surcharge totaling $1,425. The court will defer payment on that for 3 years from today's date. The court also is issuing the order of protection. The remaining counts in the indictment. The remaining counts in this 13-count indictment are dismissed as satisfied by the plea and sentence. Anything further from the people, Mr. Woodford?
No, Your Honor.
Yes,
Ms. Schwartz?
just briefly, Judge. I object to the sentence as unduly harsh and severe, and in terms of the court's factual statement that this was the result of extensive negotiations, 17 to life was the only offer that was ever provided to me.
Your comments are noted for the record.
Thank you, Judge.
That concludes today's proceedings.